Good morning, everyone. Please take your seats. We're going to get rolling. It's 9 a.m. So welcome. My name's Anita Szigeti. I'm the president of the Law and Mental Disorder Association, LAMDA, and secretary of Women in Canadian Criminal Defense, WiCCD, the two organizations co-hosting this conference. The president of WiCCD, Maya Shakiri, is here with us as well, and you'll be meeting her shortly on our first panel. Before making further introductions, we want to acknowledge that today we stand here in Toronto in the Dish with One Spoon territory. The Dish with One Spoon is a treaty between the Anishinaabe, Mississaugas, and Haudenosaunee that bound them to share the territory and protect the land. With us on the webcast are people from across Canada, and we recognize the traditional territories, treaty lands, and homelands of First Nations, Inuit, and Métis peoples, acknowledging their enduring relationship with the land and their role as stewards. We acknowledge today as well that the harms of colonialism are not all in the past. Currently, for example, Inuit embroiled in the criminal justice system, when they are found to be lacking criminal responsibility due to mental disorder, are ripped away from their home communities in Nunavut, removed from their families and detained without access to country food, their language of Inuktitut, and their culture. We continue to replicate harms of residential schools and the 60s scoop, and today as justice system participants, we commit to delivering on the truth and reconciliation calls to action for Inuit and all Indigenous peoples. A few words next about this conference. Today's full event is unique and one of a kind. Our speakers and our registrants come from all over the country and are drawn from all corners of the criminal justice system. Defense, Crown attorneys, the judiciary, forensic psychiatrists, and other mental health professionals and people with lived experience. I'm very proud to see we'll have about 150 people in this room and more than 350 on our webcast. More than 500 people have registered for this event, which is an amazing turnout. I'm joined today by Justice Jill Presser of Toronto Superior Court of Justice and Dina Bonet, Counsel at the Crown Law Office Criminal, who are the co-chairs of this event with me. The three of us welcome your interest in mental disorder and criminal justice, and thank you for being with us today. This conference is based somewhat loosely on our book that we published together with our colleague, Dr. Ruby DeHond, the Canadian Anthology on Mental Health and the Law, also known as the CAMHL for short. That book, together with others on mental health and the law, is available to you outside, and if you can lift it, I suggest you buy it. And if you can't lift it, I still suggest you buy it. I say this because if you care about this area of the law, this book is made for you. It has contributions from 70 authors who are all experts in the law of mental disorder. And whether your practice is exclusively mental health law or you have even a single file that involves mental disorder, the book is an invaluable resource for issues that are often very difficult otherwise to navigate. Throughout the day today, you will be hearing from many of the chapter's authors directly as panelists. We have assembled the most knowledgeable speakers on each panel, taking you through the criminal justice process from bail to jail. There are 8 panels presenting today, and the order of the topics is roughly correlated with the chronological development of a criminal prosecution and trial at each stage where mental health may become an issue. Fitness and criminal responsibility will be covered because that's what most of us ordinarily think of as the places where mental health issues intersect with the criminal law. But of course, those are not the only such intersections. You'll be learning today about mental health and bail, specialized mental health courts, the law of criminal code review boards, mental health at the sentencing stage, and the plight of individuals in acute mental health crises languishing in our jails and prisons. We have a very ambitious and jam-packed agenda with 40 speakers generously giving us their time and wisdom. So we're going to keep religiously to the time set out on your agenda, which is why I'm talking so fast. Our panels have received your questions submitted on the registration forms, and we'll be answering many of them. There may or may not be time to entertain additional questions today, but attempts to flag anything new will certainly be made. Finally, just a couple of things about how special this event is. First of all, as you know, this conference is free. It was open to everyone. The conference is truly national and multidisciplinary. In attendance here today, both in person and online, we have registrants who are defense lawyers, Crown Counsel, members of the judiciary, tribunal decision makers, mental health professionals, forensic psychiatrists, service users, people with lived experience from across the country. A conference like this is a monumental undertaking to plan and organize, and it took a village to make this one happen. I want to thank and acknowledge our wonderful volunteers, my co-chairs, and the co-hosting organizations, WiCCD and LAMDA, for creating this exceptional opportunity for us all, including for law students, articling students, and the newest members of our legal professions, lawyers and paralegals. I also want to very especially thank Neha Chugg of Chugg Law and Megan Stevens for our muffins this morning. There was quite a bit of a muffin gate, and you can approach me later if you want to hear the background on that. I want to thank LexisNexis for their generous sponsorship of the event and donating the mental health law books that we'll be giving away. And I want to give a shout out to Dana and Hawes and Emond for donating 3 criminal law textbook door prizes. 6 winners of our book prizes will be announced at the end of the program. And in closing, just touching on what you'll learn today, why it matters, it bears noting that there has never been a more important moment for the law of mental disorder in criminal justice. First, not only are we experiencing an unprecedented crush of persons with serious mental health issues embroiled in our criminal justice system, with rates of acute mental health crisis skyrocketing in the wake of the COVID-19 pandemic, but also all the big ticket items in mental disorder law are currently in flux and pending pronouncements that may completely change it all, as the Supreme Court of Canada has judgments under reserve that pertain directly to this topic. For example, in relation to the conditions of detention in psychiatric hospitals versus jails, there is the case of RVJW, and of course there is Barwani, which you will be hearing a great deal about today in relation to both fitness and NCR, as well as the important case on sentencing and mental health called COPE, which will be heard in our country's top court shortly. These are exciting times ahead for this specialty area of the law. And by the end of today, you will be as expert and as current as anyone, almost. We thank you for joining us. We hope you enjoy the day, and we'll look forward to your stellar reviews on our feedback survey to follow. With that, we will now begin with our panel on bail and mental health, and I would invite our panelists up. And at this point, it's over to me still to introduce this fabulous panel. On your panel on mental health and bail this morning is, of course, Justice Jill R. Presser of Superior Court in Toronto. As you likely know, Justice Presser was defense counsel prior to her appointment and devoted a substantial part of her practice to representing individuals with serious mental health issues. Cassandra DeMelo has her own wonderful firm, DeMelo Heathcote in London, Ontario. Cassandra is an expert in the law of mental disorder on bail and sentencing and other issues. And we have with us Ken Lockhart, a call to the bar in 2009, is an assistant Crown attorney at Toronto's West Office, who's prosecuted a broad range of criminal offenses and has expertise in bail. Of course, your moderator is WiCCD's president, Maya SHUKAIRY, defense counsel based in Montreal, who works in the East region, including Ottawa, and herself organized our last conference on bail, which was fantastic. So with that, over to the first panel.
Thank you. Thank you, Anita, and good morning, everyone. I'm Maya SHUKAIRY. I will be moderating this first panel, which is on bail and mental health. And I will start right away. And good morning, everyone, to my panelists. Good morning. I will start by asking a first question, and this is based on the questions that we received from the chat. The first question, and it's probably addressed to all of you, if an accused has a serious mental health diagnosis, short of NCR or fitness concerns, and history of non-compliance with prescription medication, how much is public safety and an accused risk to reoffend taken into account in bail decisions?
I can lead off. So I would say if there's evidence that mental health and medication non-compliance are related to or causes of alleged offending or past convictions, it's going to be important. So a diagnosis, a mental health condition, medication non-compliance are going to be important to bail if there's evidence or reason to believe that they're related to risk to the public. Remember that the secondary ground for detention in section 515 sub 10 sub B of the criminal code is where detention is necessary for the protection or safety of the public, having regard to all of the circumstances, including a substantial likelihood of reoffending if released. So insofar as a mental health condition and or medication non-compliance are related to risk to the public, these will be very important considerations on bail. And then the question for the bail judge will be whether a release plan can be put into place that will adequately mitigate the risks to the public raised by an untreated person with mental health issues. I want to emphasize that the mere fact of having an untreated mental disorder on its own doesn't necessarily raise primary or secondary, any bail risk, secondary ground concerns. Remember that in WiCCD, the Supreme Court of Canada held that we cannot assume that all people with mental health issues are necessarily dangerous. This is stereotypical, impermissible stereotypical thinking. And so if there's no reason in the evidence that suggests a defendant's diagnosis and treatment non-compliance give rise to secondary ground concerns, this should not be taken into consideration in bail decisions. In other words, it's a mistake to assume that just because somebody has a mental health issue or is treatment non-compliant for a mental health issue, it's a mistake to assume that that on its own gives rise to a substantial likelihood of reoffending. There has to be a reason in the evidence to suggest that mental health and treatment non-compliance are relevant to risk.
Pick up on that?
Yeah.
Go ahead.
So I'll be interested to hear what Ken has to say on this too. From the defense perspective, the talk about evidentiary foundation is interesting because from a practical level, I don't know how much information is available to anybody when you're getting someone in, less than 24 hours, having a bail hearing. In practice, if that's actually happening, I mean, not always the case, as we know, but it's a very fast turnaround, as we know. And so when you're on the ground, unless that person has a significant history with the courts, I actually don't know how much of that information is even available to any of the parties, including the Crown. And this is where I'll ask Ken for his input too, because you may learn that in cells talking to your client. You may learn that from a surety, for example, that you talk to, that there's this issue. And so if you're a defense counsel, then you really need to think about whether or not you even want to raise that as a red flag, potentially at the bail hearing, and have that evidence come out that a surety is concerned that they're not medication compliant. Because then if you raise it, all of a sudden that becomes the thing that is spotlighted, right? And so it's not to say that we don't want to make sure that people are medication compliant if that's what they want to do. And I know Justice Presser and Anita and a bunch of us are big proponents of consent and making sure that medication compliance is consensual. But my point simply is that from the defense perspective, you'll want to be careful what type of evidence you're tendering so that you're not the one putting that spotlight on it, unless you also have a plan. Right? So only spotlight it if your surety is going to be able to say, I'm concerned about medication compliance, but I know that they'll listen to me if they come and live with me. And when they stay at my house, they always do well, for example, right? And then they will stay medication compliant, and I'll make sure of that. But as we know, so many people who face mental health challenges often lack those kinds of supports or direct supports, one-on-one supports, like someone who they can go live with. So if you've got a client who their best plan is some sort of bail supervisor program and maybe like a shelter that they're going to be living at, they're transient in some way, I don't know that I'm putting the client up there talking about how they're medication non-compliant, right? And so just be careful where the information's coming from, and that you're not raising it or causing that spotlight to be on there unless you know that you can also address the issue.
So the great thing about speaking after Cassandra and Justice Presser is I just parrot what they say and change the words a little bit, and then I sound really smart. But at a high level, there's nothing wrong or unjust about considering a person's risk to public safety when making a bail decision, even though that person is a member of a vulnerable community or has particular vulnerabilities arising from mental health concerns. That's exactly what the secondary ground is about, and we'd be derelict in our duty to not think about that and consider that. But what is wrong is to take common stigmas about mental health and mental disorder and make assumptions about that a particular person's dangerousness based on those stigmas or stereotypes. And specifically, we can't conceptualize people with mental disorders as these free-floating bombs of dangerousness that are going to go off at some moment in the community unless we detain them or unless we do X, Y, and Z. That conceptualization is obviously wrong, and I think that's exactly what Justice Presser was saying about evidence. Something I argued the last time I was in this room, and what comes across in the Supreme Court's decision in Zora is that the bail system fails when it's not individualized. And that's what I think is so critical about bail. When you're faced with a person, as a Crown, you have little more than the show cause notes from the police and your conversations with your friend opposite. But when you're faced with a person whom you are vaguely aware has a mental health disorder or mental health concerns, it's really important to, as much as you can, based in the evidence, turn your mind to the specifics in that what is the mental disorder that's at issue? Has it influenced the current allegations or past criminal behavior, if any? And then how does that person's history with compliance or non-compliance with medication and compliance or non-compliance with conditions impact that assessment? And focusing in on that individualized question, my opinion, leads to better outcomes. You're going to have a much different assessment when you have a person who's bipolar, who's in your bail court facing another threats and an IPV breach, versus a person who has half a dozen convictions for various kinds of violence and suffers paranoid delusions. There's nothing wrong with making a public safety assessment in those two contexts, so long as it's based on evidence. And I do have to acknowledge what Cassandra said in that at the bail stage, that's incredibly difficult for everyone. Counsel's coming in, maybe it's a new client who they just got a call from a family member the night before. As the Crown, all you have are these little notes from the police about their interactions with the person. And it can be very dangerous or very difficult to make a meaningful evidentiary-based assessment about that person. But that's in my opinion, what's required, is to think specifically about the disorder at issue, how it impacts the secondary ground concerns. And if you're doing that, there's nothing wrong and a lot right with thinking about risk to public safety and bail decisions.
Thank you. My next question is, how can counsel access supports, services faster as to influence informed bail decisions?
So I'll start on this one so I can prove that I actually have intelligent things to say that aren't copying my co-panelists. This is, to me, less about accused with mental health risks than it is about the practice of law generally. I think we can all agree and say very simply that those kinds of resources are very difficult to access at the bail stage in any context. There are physically offices at the courthouse and what have you that can assist, but time, place, demand, it's all very busy. My opinion now in 2025 is if you want to get at these faster, pick up the phone, change how you interact with people in bail court. We're all doing bail court remotely, and a lot of that is based on, my opinion, this false belief that email communication is always faster and more efficient than voice or in-person communication. And that's, to me, obviously not true. In these difficult situations where you're trying to access resources to articulate intelligently what's available to this person that might help a bail decision, get on the phone, have a 10-minute conversation with a courthouse's mental health worker, and you're going to resolve all your questions and issues that might take 5 hours to resolve by email, because you're sending a question and then they're busy and then they're not getting back to you, and then they respond and that raises another question and it takes you a while to get back. So get out of this mode of I have to do particularly in a remote bail court, that I have to do everything by email. Talk to people. We're lawyers. And even though there's so few resources to be had, you're going to get at them faster if you improve the efficiency of your communication.
So I'm going to crop that part of this panel and send that to our London Crown's office and say, Crowns say that picking up the phone is better. And I only say that because in London, we've become complicit in that too. We email all the time. And for us as defense counsel, it becomes a bit difficult because we're told, no, you can't, that person's not available. You have to email this generic email inbox now and hope to get an answer from that. And it's infuriating because, you send in a bail vetting, like surety declaration form and the ID, and it takes 5 hours to get back, when in the good old day pre-COVID, I could walk down to my local police satellite office, hand it in, and within 10 minutes know if my surety is approved or not. It's just these simple things that I think we've really lost with the introduction of Zoom and COVID. For all the good, there's also negatives. And so I echo those comments too, that, yeah, of course, picking up the phone is going to be the fastest way. But I'll say this too, is that don't wait until the Crown's position comes in to know whether or not you should start working on bail plans. Assume as soon as you get that call, if you're defense counsel, that you want to create the strongest plan possible for your client. And what I mean by that is start making those calls and those inquiries as soon as you get that call. And then you don't have to present those all to the Crown as part of the bail plan if you don't end up needing it. Like, let's say they consent with just a John Howard Society bail supervision release, but you've got the surety lined up already just in case too, right? Same goes with these other services. I again am London local, so I don't know the services in all the other cities, and I'll never profess to, but get connected and get informed with what your local services are in your city, and then have those numbers on speed dial essentially, and have it ready to go, that when you have someone with mental health concerns, you are already knowing who to call and you're starting that process right away. The difficulty for, of course, most of us is that if they're not already connected or referred in some way, you're probably not going to get a connection or a referral while they're sitting in a cell and you're in bail court. That's just the reality. And so also be realistic about how many services you can connect the person with ahead of time. I mean, again, speaking locally about London, CMHA is fantastic. We have a therapeutic court in our jurisdiction. The problem with it, though, is that it only runs once a week. And so the psychiatrists and the other support workers that are there are only there on Wednesdays. So don't get arrested Monday, Tuesday, Thursday, Friday, I guess, right? And so that's not super helpful, but it's something at least, right? And so we have people that you can connect with, but sometimes it's just also facing the reality that you may not ever get that person connected while they're in. So work on other ways of strengthening their plan, and then have a list ready to go for people they can connect with when they're out, so that they're less likely to reoffend and find themselves in the revolving door.
I wasn't going to weigh in on this, but I feel I want to. Defense counsel are in a very difficult situation when representing clients with mental health issues, particularly at the bail stage. And Cassandra was referring to this. You're often dealing with people who are very vulnerable, who don't have a lot of supports or resources in the community, and there aren't a lot of resources available. And you want to create a bail plan quickly, and the resources aren't there. And I just kind of, first of all, wanted to acknowledge that. And also for defense lawyers representing clients in this population, there often isn't a lot of funding. You might be accepting a legal aid certificate. You're taking on a client who has a lot of needs without a lot of resources available and without a lot of funding to assist you in taking on the file. So I kind of first want to acknowledge that that's a real thing. And many of your judges will be aware of that. That having been said, I think it also bears saying that if you as a defense lawyer are taking on clients in this population, I think to do the job properly, you're gonna have to be ready to go above and beyond. You are going to probably have to do work that you will not be able to be paid for by legal aid if you're on a legal aid certificate. And very often at the bail stage, you are going to have to make extraordinary efforts to try to put a plan together for your client. Obviously, that's not every case. Sometimes there'll be John Howard or St. Vincent de Paul, or in Toronto, Fred Victor, that will assist and provide supports and resources on a voluntary basis for your client. And in some cases, that's going to be enough. But in some cases, particularly the ones I would see in the Superior Court, where it's a 90-day review, so the person's been detained and they've been inside for over 90 days, or on a bail review where somebody's already been detained, typically in the cases that come before me, sort of, or very often, a sort of bail program supervision plus Fred Victor on a voluntary basis is not going to be enough. And as defense counsel, you're gonna have to make extraordinary efforts to try to marshal resources and put a plan in place. And I want to be clear, what I'm not saying is the court is holding you to a higher standard, but what I am saying is, as a practical matter, if you're gonna practice in this area to serve your clients, sometimes extraordinary efforts are going to be necessary.
If I can just pile on Her Honor's point, with which I entirely agree. A very wise friend opposite of mine sitting at this table a few months ago, talking about bail, used the phrase, sometimes speed kills. And the very difficult practical reality in this context, I think, is that, and I'm not defense counsel, but particularly for defense counsel, is you come in the morning after arrest with a person who's a member of a vulnerable population and is facing an accusation that isn't particularly violent or egregious, and there is a lot of pressure to get that person out of custody as fast as possible. But I think the practical reality is, if it takes you 72 hours to get to resources that this person can access in the community and create a persuasive bail plan that might get a consent out of the Crown or a ruling out of a justice of the peace, that might serve that person better in the long term, in their ability to secure their exit from custody in the long term. Now, that's different from using custody to house mentally ill people. That's obviously wrong. But I think the real practical reality is if you take a breath and say, I need to know about this person and I need to know what's available to this person, and if that takes 2 days, you may reach a better bail outcome in the long term.
Thank you. Now, since we're talking about vulnerable people, we're getting more specific here, and how much, if at all, are sections 493.1, 493.2 of the Criminal Code influencing bail decisions?
I can start. So back to my point before, only put a spotlight on this if you're ready to have meaningful comments about it at the bail hearing, and raise it as an issue without raising it as a red flag. But absolutely, if your person has a mental health concern, then you should be flagging it, as that does make them a vulnerable person as defined by 493. And so you will need to call some sort of evidence of that likely. And again, that's where I caution you to be very crafty and careful about how that evidence comes up. If you're putting the client themselves on the stand, because that's your only option and it's the only way that you feel you can get across to the JP that they're going to comply with the bail order, then make sure that your client discusses their mental health challenges and, you know, maybe talks about what services they've accessed in the past that were helpful and whether or not they plan on accessing those again or revisiting that. If you are going to put them on the stand and you have concerns about their ability to do so, I mean, at the end of the day, I always go to the principled thought process that it's the client's choice to take the stand or not. That's at bail or at trial. But be willing to give advice that maybe taking the stand isn't always the best bet either for someone if you don't think that they're going to be able to have a coherent or persuasive time testifying. And so then it's a question of how are you getting that evidence in otherwise. We all know the bail evidentiary rules are relaxed. And so it could just be that, you know, a surety making passing reference to it is enough. You know, I know that they've seen a doctor before and they've been diagnosed with X. Maybe that's enough for your bail justice of the peace or judge to consider it. But again, if you're going to have anyone talk about mental health, it should probably be a little bit more than surface level. Otherwise, it might just raise more question marks.
So I want to disagree with Cassandra a little bit. 493.2, which is the provision that says in making bail decisions, judges shall give particular attention to the circumstances of Aboriginal accused or vulnerable accused who belong to a vulnerable population that's overrepresented in the criminal justice system and that's disadvantaged in obtaining bail. That provision you may or may not want to put before your judge, as Cassandra says, depending on what evidence you can marshal. And in some circumstances, it might not be in the client's best interest. If there isn't other evidence of mental disorder, might not be in the client's best interest to put that before the court. But where I disagree is 493.1, I think you always want to put to your bail judge, because that is a codification of the principle of restraint. And it says a bail judge shall, it's mandatory, give primary consideration to the release of the defendant at the earliest reasonable opportunity and on the least onerous conditions that are appropriate to the circumstances. So that's basically a codification of Antic and Zora. And it's something that I think you want to drive home to your bail judge always, right? It's one of those principles, like the charter right to reasonable bail, that a bail judge should always be reminded of. In terms of, you know, both of these, well, the 493.2, the vulnerable population, there's a robust jurisprudence already around what are quote unquote vulnerable populations for the purposes of 493.2. It's already well accepted in that jurisprudence that people with mental health challenges are a vulnerable population that's overrepresented in the criminal justice system and that's disadvantaged in obtaining bail. And that this vulnerability, the vulnerability of people who have mental health challenges and need for particular attention in bail, may be greater where mental health challenges intersect with membership in other vulnerable communities. So I just point that out. Intersectionality is something that bail judges are looking at. I think it's important to remember that both 493.1 and 493.2 are mandatory. The language of the provisions, you know, direct a judge. They say the bail judge shall consider these factors. So they are things we are required to look at. And so all of which is to say 493.1 and 493.2 are very important considerations in bail hearings for defendants with mental health challenges. That having been said, the fact that a defendant is a member of a vulnerable community isn't going to supersede the requirements of section 515 sub 10 of the criminal code. And I have a quote here from my brother Justice Schreck in a case called B like Bob, 2020 ONSC 4383 at paragraph 42. And what Justice Schreck says there, I'm not going to read out the whole quote, but basically he says that 493.2 isn't going to supersede the primary, secondary, or tertiary grounds. And here I will quote, what this means is that regardless of the accused's circumstances, if his detention is necessary on the primary, secondary, or tertiary ground, then he cannot be released. If there's a substantial likelihood that the accused will commit further offenses if released and thereby compromise public safety, the fact that systemic or background factors contributed to that substantial likelihood does not change the result. A dangerous person is no less dangerous because he or she is a member of a vulnerable group, end quote. So what you're looking for is, as defense counsel, you're looking to make an argument that there is vulnerability that needs to be considered with defendants in this population on bail, but that the person's risk don't rise to substantial likelihood on the secondary ground.
Your Honor, I'm disappointed that you think your defense panelist would ever say, don't bring up the principle of restraint. That was me being a bad advocate because I wasn't clear that I was talking about 493.2, always mentioned 493.1. With that aside, off to you.
I see two aspects to this question. Sorry, neither of which are particularly about principles of bail, unfortunately. First is history. These sections came into effect in 2021, which is 1 year after Zora, but 4 years after Antec. So in my experience, I didn't see a big change in how these variables were assessed in 2021 as I did in 2017. For those of us who've been around that long, if you think to how bail court ran in 2012, 13, 14, and compare it to after Antec, I saw very significant change with a particular emphasis on the principle of restraint, members of vulnerable communities, and accused Indigenous heritage. These sections codified that in 2021, but I confess I did not see as much of a change as I did in 2017. And I think that's because that change had largely already been made. The second point I see on this question is really one of litigation tactics, which I think a lot of what Her Honor was saying gone into. The Crown can never and would never say, don't follow the principle of restraint, or they're not going to stand up and say, well, that person doesn't really have the mental disorder that my friend says he has, or that person is not Indigenous. I mean, that's just not going to happen. So as a matter of litigation tactics for defense, if you make that the centerpiece of the not the centerpiece, but an emphasis in your hearing, these are issues that are near impossible for the Crown to respond to if the Crown is seeking detention. So perhaps not the greatest advice for my colleagues, but for my friend opposite, as a matter of litigation, highlighting these in the hearing is only going to assist whatever you're seeking.
I just want to ask a question to clarify that the Crown will not say that this person doesn't have a mental health issue or is not Indigenous, but there have been some situations where there were questions as to which populations these sections apply. Like, for example, they don't apply, let's say, to Latinos or Muslims. So let's clarify that point. Like, do these sections apply in this context?
Well, if my colleagues have taken an opposite position, I'm not going to speak for the Attorney General, but strictly in terms of litigation tactics, particularly as a middle-aged white man, there's just no traction in me standing at a podium and saying, no, this Muslim person is not a member of a vulnerable community. I'm not answering the question substantively, but I am saying is at litigation, you got to recognize where there's traction and when there's not. And I would wager that argument did not go well for one of my colleagues who made it.
Yeah. All right. What role should mental health professionals play in shaping bail decisions for accused persons with mental disorders?
I suppose I'm up. A hard question that I think links to something I was saying earlier about speed and accessing resources. In that, when you have a person who faces mental health challenges, certainly as the Crown, you very much want to know how a medical professional, their view on this person. You know, when I'm arguing 20 minutes ago, you need to know specifics from this person's mental disorder and how that relates to the secondary ground. A medical professional or a psychiatrist is obviously better placed than you to understand that and explain that. So you want that. But getting back to practical realities, that's not something that's going to happen in 18 hours. That's just not going to be. And at the same time, it's an abdication of your duty as a Crown to totally defer your position on bail to a medical professional, even if the accused you're dealing with is a member of a vulnerable population.
Yeah.
So what I'd want most, if it's available quickly, is an answer to that question. How does this person's specific mental disorder relate to the secondary grounds? And while that is a critical question, you can't let it overwhelm your full assessment of bail as a Crown.
Yeah, there's a reason that the NCR question, for example, or the fitness question are still legal questions at the end of the day. They are influenced by medical professionals, but it's a question for the judge. It's the same with bail, right? And so you can use the opinions of mental health professionals to maybe inform the legal decision, but at the end of the day, I don't think that they ought to be given the full final decision. The other thing I'll say, which ties back into what I said earlier, is if you're also connecting your client with someone who they're only meeting for the first time and you're trying to even, slow things down for a few days enough that they're connecting with them, you've got to be careful that I don't know that a full assessment and a full diagnosis can be made in that kind of a time frame either, right? There's the opportunity for error and the opportunity for not fully understanding the person and their diagnosis. So unless you're looking at long-standing history of their mental health diagnoses, I'm not sure that I would even put much weight on something being done that quickly, right?
Nothing to add, I agree.
All right. Can treatment be ordered as a condition of release?
I'll lead off on this one. My short answer to this question is yes. I wrote a decision considering this issue. It's a case called R&RS 2021 ONSC 6732. And I specifically consider that question at paragraphs 47 to 63. I won't go too deeply in the interest of time into my tortured musings on the questions. You can read the decision, but my conclusion at paragraph 61 of the decision, relying on the Supreme Court of Canada, mostly relying on the Supreme Court of Canada decisions in Zora and Myers, was that conditions requiring treatment for addiction and or mental health can be imposed in bail, but only where a number of conditions are met. Firstly, that the treatment condition is necessary to address specific Section 515 sub 10 grounds for detention that would otherwise prevent release. Secondly, that the treatment condition is as minimally intrusive as will address the Section 515 sub 10 risks that would otherwise prevent release. Thirdly, that the treatment condition doesn't contravene federal or provincial legislation or the charter. And fourthly, that the defendant subject to the treatment condition is likely able to comply. In RS, I released the defendant with a treatment condition to take treatment as directed by his surety in consultation with mental health professionals. And one of the things that I grappled with there, we're running out of time on this panel, I won't go too deeply into it, but one of the things that I really grappled with is the question of consent. And, as we all know, there are almost no examples in law of where a person can be treated where they don't consent or where there isn't consent on their behalf by a substitute decision maker. There's one example in the criminal code which relates to treatment orders to make a person fit, but those are pretty exceptional. So I grappled with the question of consent, and where I ultimately landed in RS is that RS had talked about treatment with his surety. He knew that his surety required treatment as a condition of her acting as surety. And he was prepared. His evidence was that he was prepared to take treatment as a condition of release at the direction of his surety. And I ended up coming to the conclusion that on the facts of that case, that was enough as a kind of form of consent, and that ultimately, if he wasn't, while there was a risk of coercion and overriding his consent, ultimately, if he wasn't prepared to take treatment at the direction of his surety, he could either not comply and go back into custody, or there could be a bail review. But I just want to highlight, I mean, for the reasons I give there, treatment, I think, can be ordered as a condition of bail, but that you want to be very sensitive to treatment conditions that are overly coercive and treatment conditions that end up nullifying a legal requirement of valid consent to treatment.
So I'm just seeing the sign that we have to stop. So unfortunately, that
Oh,
would
don't be, yeah.
that will be all that we can cover. I do see that we have questions here, but we'll see if we can find another way to have them answered. Thank you very much.
Thank you.